Welcome to Clarity, a podcast powered by the Thomson Reuters Institute. I'm Zach Warren, the Institute's Technology and Innovation Insights lead. In each episode, we dive deep into a single question from decision makers and thought leaders from legal, corporate, tax accounting and audit, and government communities. In today's episode, we discuss the big question: what must change in America's legal education system to make new graduates practice ready? There is a quiet crisis that judges across the country say is playing out in their courtrooms every single day. Too many brand new lawyers are stepping into practice unprepared, and clients are paying the price. To help solve this issue, a group of chief justices and court administrators from across the U.S. on the National Committee for Legal Education and Admissions Reform, or CLEAR, set out to find an answer through research. Their findings indicate change is needed, as nearly 60% of judges say a lack of readiness is harming client advocacy. Today, TRI's Natalie Runyon sits down with Chief Justice Gordon J. MacDonald of the New Hampshire Supreme Court. Chief Justice MacDonald is also the chair of CLEAR, and he talks on the research findings and his thoughts on how each part of the profession could contribute to the change.
Well, Chief Justice MacDonald, thank you so much for joining us on the podcast today.
Well, thanks so much for the opportunity. It's great to be with you.
Wonderful. Well, let's jump right into the question. So, Chief Justice MacDonald, you were the chair of the Committee on Legal Education and Admissions Reform, and I wonder if you could please start with some background, such as what prompted the creation of this committee, why was it done, and what were some of the urgent drivers that led to why the CLEAR research was done now?
Sure. Well, the committee is a committee of an organization called the Conference of Chief Justices, which is made up of the 56 state and territorial chief justices, and then the Conference of State Court Administrators, which are the folks who administer our state court systems. And they came together in July of 2023 and passed a resolution creating our committee. Why was it created? State courts actually handle 98% of all litigation in the United States. Federal courts have very important jurisdiction, but it's relatively narrow. State courts immediately touch the lives of Americans when they have a dispute or they need to be before our court. So it's an incredible volume of cases that we hear every day in our state courts. And as a consequence, we feel most directly the effects of the challenges our profession are facing. And that truly was the principal driver behind this project. And so what are those challenges? Well, first, there's this incredible rise of self-represented litigants in our courts. In just to give you an example of my state, but it's not unusual, in our circuit court, which deals with issues such as divorce and parenting, small claims, landlord-tenant, domestic violence, misdemeanor crimes. In other words, this is exactly the kind of case I was talking about, directly and immediately affecting the lives of people. Up to 90% of litigants are there without a lawyer. They are self-represented. And again, our data is very similar to what's going on in other states. The second phenomenon we see and a challenge that we're facing as state court systems are what is known as legal deserts, where you have geographies, counties with less than one attorney per 1,000 people. But the phenomenon of too few lawyers serving our population, I want to make clear, is not limited to rural areas, although it's really affected there and greatly highlighted there. It's also our urban areas. So legal deserts and the inability to access lawyers is the second challenge we face. The third challenge we face are the pressures on our public interest lawyers. Public interest lawyers are those who do just that, serve the public interest. our public defender's offices, our prosecuting offices, our civil legal aid attorneys, and attorneys representing interests and causes. And those public interest lawyers are facing a huge challenge in terms of retention of lawyers that they bring in and ability to recruit quality talent and meet the demands of their offices. Another challenge we face is the fact that our profession is just changing. And COVID, the pandemic was sort of brought a lot of this to light and was in some way an accelerant. But the nature of the practice is changing. There's more use and reliance on remote hearings, for instance, partly a result of the pandemic. And people are changing the way they practice, the locations that they practice in, the settings that they practice in. So that's had an effect. And then finally, and this is where the great research from Thomson Reuters really underscored this and gave proof to this. There's a perception that new lawyers are just not practice ready, inasmuch as it is state courts that regulate the profession of law in each one of our jurisdictions. And so that regulation touches on legal education requirements, both undergrad and law school, and admissions requirements. The test, it's typically a test of minimum competence that has been typically and historically assessed through a bar exam, as well as character and fitness issues. So a good chunk of our authority in regulating the profession is focused on education requirements and bar admissions requirements. So the challenge of CLEAR was to look at that regulatory authority and look at the opportunities it presented in light of these great and urgent challenges that state courts are facing.
Well, thank you so much for going into such great detail on the challenges and that are, broader than the research, but certainly are underlying factors that may indirectly, impact the reality and the perceptions around new practice readiness of new lawyers. So in your view, what would be the ideal outcome or outcomes occurring as the result of the CLEAR research?
We reported back our report, which is an executive summary and a big, thick compendium of our research. And really what we hope to do is to empower state courts. And we did a really profession in their jurisdiction as the regulators to lead efforts and collaborate with the stakeholders in our profession to really examine and, where appropriate for the jurisdiction, engage in meaningful reform aimed at addressing these challenges that we face as a profession, using the tools of our regulatory authority with respect to education and bar admissions.
So I want to turn now to the research. From your perspective, what were the key insights from the CLEAR research? And were there any insights that surprised you and maybe didn't surprise you at all?
Yeah, so just to back up, our effort involved listening sessions around the country. We literally, Chief Justices traveled around the country. We convened listening sessions among stakeholders. We did a number of one-on-one interviews with those who are interested. We had a national convening of stakeholders. But very, very importantly, we wanted to get real, and we compiled research and the existing literature in this area. But what we really wanted to do was add to all of that by having and compiling actionable data on particularly the issue of practice readiness. And so we turned to our partners at Thomson Reuters and constructed two surveys. The first was of sitting state court judges. And we had over 4,100 sitting state court judges, mostly in the trial court setting, respond to us, representing, this was incredible, all 50 states, 3 territories. So just a really good sample. And I was just so pleased with the response we had from our state court judges. And then we also sampled, recognizing that not everyone and every lawyer is in court, and we wanted to assess practice readiness in other practice settings. So we also surveyed, again with Thomson Reuters' help, practicing attorneys and new law students. So of those surveys, I would say that the thing that was least surprising but very confirming of our perception, our instinct, was that our judges really do detect a practice readiness problem. 2/3 of the judges, according to the survey, state that they sometimes, rarely, or never observe attorneys with less than 5 years of experience competently conducting either direct or cross examinations, to take one example. And that's not the only deficit they observed. I'm just pointing to one. But a really important conclusion from the judge survey is that these limitations on new attorney skills are affecting clients, are affecting the clients they represent. 50% of the judges, our judges, say that they agree or strongly agree that the litigation skills of newer attorneys have actually declined over the last 5 years. Another really important data point, not necessarily surprising to us, but did confirm what we were feeling. A surprise of the survey, really of our 2 surveys, really came from the attorney and law school surveys, which showed remarkably strong support for the development of innovative pathways to the admission to the bar. So I mentioned earlier that the principal test of minimum competence that state courts have used is the bar exam, the traditional bar exam, which in the overwhelming number of jurisdictions is a 2-day bar exam composed of a multiple choice component, an essay component, and a practice component, which is called the Uniform Bar Exam. A number of states, 7 at present count, have adopted non-exam pathways to admission to the bar. And several other states are examining non-exam pathways to admission to the bar. And we can get into the details about what those are, but what surprised us was how much support there was among lawyers and, less surprisingly, law students for a non-exam pathway to get admitted to the bar.
Well, thank you so much for elaborating on those insights and looking at the insights that stood out to me. One of the ones that was really just kind of shocking was that nearly 60% of the judges reported that the lawyer's practice readiness is harming client advocacy. So that's a really big number. And from the lawyers' feedback, just over 40% of lawyers say that they believe that law schools provide students with the necessary skills and knowledge to adequately practice law. I mean, that means 60% don't believe that, right? So that was also, very surprising, just the sheer number. And so the other thing that I thought was really interesting from the research is that a lot of comments and a lot of feedback on the fact that mentorship and hands-on experience are proven to prepare lawyers, but are insufficient to really close the practice readiness gap because it is so resource intensive. And so it really just goes to show you that, yes, there's a lot to be done to change within law schools, but it's also a profession-wide problem, right? Because it really requires those volunteers, the supervisory components that are so essential to be practice ready. And we'll come back to your thoughts around what parts of their practice or in the legal ecosystem, judges and those in public service, et cetera, should be leading on, specific recommended actions. But before we get to that, I was wondering if you could talk about just generally what steps are necessary to make the actionable insights a reality from your perspective.
I think a very important piece of it is to engage all stakeholders in the urgency of the challenges that we're facing as state courts. It is just not acceptable that that so many people are without lawyers, that so many public defenders discharging a constitutionally required duty are so resource constrained, that there are vast geographies without adequate lawyers. I mean, these are immediate challenges that we're facing as a profession. And all of us are in this together, and all of us need to join together to address them. One of the graphics that we have in the report is an image of gears, and the gears represent the various stakeholders in the sphere of this ecosystem, as you said, of legal education. We have obviously state Supreme Courts, we have accrediting bodies, we have obviously law schools, we have the local bar associations. Supreme Courts in particular are uniquely positioned to convene and to bring people together, to identify these issues, and through our report, identify some possible solutions and get stakeholders engaged in the challenges and having a conversation about how we can work together to address them.
Great. Thank you so much for elaborating on that so thoughtfully. One area of the research that I wanted to get your perspective on is the fact that that the research indicated that there was a need to increase experiential learning, both in law school and in the first few years of practice, which kind of goes to that supervisory and mentorship that I mentioned a few moments ago. It strikes me that this is an area where AI could really, help. And so I was just wondering if you might reflect on that, but more broadly, what are your thoughts on how this insight should be put into action?
Well, it's again, we've got the data to back it up. I mean, there is a practice readiness gap. And so what are the tools we have? Well, we can work with law schools to increase experiential learning opportunities. We can adopt pathways to admission to the bar that emphasizes experiential learning and experiential opportunities. And practicing members of the bar, once new lawyers are actually out there, bar associations can work together and create opportunities for new lawyers to have experiential practice-based opportunities, and also to develop CLEs around experiential learning, continuing legal education opportunities. As I think you alluded to, the challenge with experiential learning is its scalability. It is very resource intensive. There's no question about that. But that's where AI offers such potential hope. And to use the AI tools to, for instance, assist new lawyers with their writing, not do the research, but with their writing skills, which is a deficit that we heard from law schools, and they are dealing with an education deficit at the undergrad level and at the high school level. This is all, flowing into the law schools, and AI is a potential tool there. Another area that I'm really interested in is the use of AI in simulated to help us create simulated experiences for law students. Again, to have real clients are there and real judges is very resource intensive. But if we can leverage AI to create meaningful simulated experiences, that can help us, begin to close the experiential learning gap.
It was interesting. I was speaking to a group of associate deans at a conference over the summer, and the creativity that was in the room in using AI, and a lot of the faculty were actually associate deans, but they also taught legal writing classes. And so I was hearing about how they were using AI to, incorporate these simulations and use it as a kind of a first cut to share feedback. And so I thought that was pretty innovative and something to definitely build on, as you pointed out. So, final question for the podcast here, Chief Justice MacDonald. What are the immediate steps for the profession to action the results from CLEAR? And in your view, what parts? So by parts, I mean like the subpopulations, judges, deans of law school, the ABA, law firms, bar associations, general counsel. What parts of the profession should lead on specific items?
Yeah, first of all, I just want to note it's going to differ jurisdiction to jurisdiction. Every jurisdiction has its own outlook, its own needs, and I think state courts are going to respond differently based on their localities. I do think, as I said earlier, that as leaders of the profession, as regulators, Supreme Courts play probably the central role in addressing this and bringing people together. I think each one of the components that you mentioned will, in that collaborative conversation, have to look at what impediments exist in their own sphere to achieving reform that will help us address some of these issues. Those are the challenges that they face. And there are, as we identified in our report, impediments among the various actors, structural impediments among the various actors. The legal profession is in some sense, very slow to change. I mean, it's an ancient profession and its change is hard. And lawyers are particularly deliberate and careful about making changes, and that's good and appropriate. But we also have to understand that the urgent needs of the people we serve are going unmet, and we really need to look at what opportunities are immediately available to us. So I think, to answer your question, it's state courts convening the stakeholders and working together to come up with meaningful reforms. And that experiential learning is all under the supervision of members of the Board of Bar Examiners. So if you get through all of that, at the end of the course, the members of the Board of Bar Examiners will say to us, the Supreme Court, they have met the requirements of the program. These are qualified lawyers, and they should be admitted without examination. And they are. And that's called the Daniel Webster Scholar Program. And we've been doing it now for 21 years. And it resulted from that very collaboration and recognition of a challenge that we faced in our state, and coming together and working together and coming up with something truly innovative. And I will just say, I was in private practice for many years before I went into public service. I was the Attorney General, and now in my current job, I've had a chance to hire graduates from this program. They are qualitatively better than their peers because they've had these opportunities. So that excites me. And that was right for our state. I mean, it was, and other states are going to convene their stakeholders and come up with what's right for their state to meet the challenges. So the purpose of CLEAR is to offer roadmaps and ideas and best practices and the data supporting it all, and give the tools to those jurisdictions who want to go down that path.
Well, yeah, no, thank you for talking about that. The CLEAR research is the most thorough I've ever seen on this topic. And I remember wanting to write a blog post about alternative pathways to licensure during the pandemic, because a lot of states were, people couldn't gather in a room to take the bar exam. And so I remember interviewing someone about the Daniel Webster program, and I remember thinking, wow, that's a really impressive program, but it takes a lot of resources to actually execute. So I think it just illuminates both the opportunities and the challenges that we've talked about here today. I would just encourage.
It's very resource intensive, but that if we can identify alternatives, including through AI, that offers such potential.
Absolutely. And so I want to encourage people to go take a look at that CLEAR report. It is fascinating, interesting, and it really gives you the toolkit to go put something into action and to explore. So thank you, Chief Justice MacDonald, for spearheading the initiative as the chair of the Committee on Legal Education and Admissions Reform. Thank you so much for coming on our podcast today. I really appreciate it, and I've really enjoyed our conversation.
Likewise. Thank you very much. Thanks for all your help.
Thank you, Chief Justice MacDonald and Natalie, for your insights. When research reveals that more than half of judges believe new attorneys shouldn't be in court without more training, my ears certainly perk up. But as Chief Justice MacDonald noted, this isn't just a missive from the judiciary. Systemic change requires buy-in from all sectors of the legal world, including not only law schools, but new lawyers themselves to be prepared. To tackle a large problem, you need a first step, and I'm glad to have this data to begin working toward better client advocacy overall. Thank you as always for joining us for Clarity, powered by the Thomson Reuters Institute. You can follow or subscribe to this podcast on your favorite podcast platform, and don't forget to share with your colleagues and leave a 5-star review. For more data-driven analysis of today's professional services market and in-depth conversations with industry thought leaders, please visit us online at thomsonreuters.com/institute and follow us on LinkedIn under the Thomson Reuters Institute. Clarity is a production of Thomson Reuters, copyright Thomson Reuters 2025.